This was a trial should have never been brought, but if we had a jury, it would have been fair, at least, even if it was a somewhat negative jury, because no negative jury would vote against me. But this judge will, because this judge is a very partisan judge, with a person who's very partisan sitting alongside of him, perhaps even much more partisan than he is.
That was Donald Trump attacking the principal law clerk of Justice Engoron in the New York Attorney General civil fraud case. I'm Ben Meiselas from the MeidasTouch Network. Donald Trump initiated a Rule 78 emergency proceeding against Judge Engoron to try to stop the gag order that was imposed on him and his counsel for their consistent attacks on Judge Engoron's law clerk. Judge Engoron imposed that gag order back on October 3rd. Donald Trump subsequently violated it twice. He was held in contempt twice, one of those based on MeidasTouch reporting where we identified offending posts by Donald Trump remained up on his campaign website. Now the New York Attorney General's office has filed a very powerful appeal before the Appellate Division First Department, and they are saying there should absolutely not be a stay or a temporary pause on the gag order that was imposed on Donald Trump, and that since a stay has been put in place by the Appellate Division, Donald Trump has continued to attack Judge Engoron's law clerk, and the court is receiving a deluge of threats and attacks and death threats over and over and over again by Donald Trump's conduct. When you go through this briefing by the New York AG's office, a 54-page filing, at the heart of it is like this type of behavior, Appellate Division, would undermine the ability of our trial courts in New York. In New York, the trial court is called the Supreme Court. It's a bit confusing. The Court of Appeal is the top court. The Appellate Division is the intermediary department. But the New York Attorney General's office is saying this would cause grievous harm to our abilities to conduct trial if litigants are behaving this way. And while, of course, everyone has a very important First Amendment right, we're talking about what goes down in trials. The behavior in the courtroom, the behavior during trials, the behavior during active litigation. For members of the bar, like Donald Trump's lawyers, to conduct themselves this way is completely the opposite of how lawyers should behave. Unprofessionally, they're behaving just immaturely, they're behaving without any respect for decorum, and judges have the right to regulate what goes down in their courtroom. So one of the arguments right there is, no, judges can tell lawyers, stop behaving. We're just going to let lawyers run the show now. Are you kidding me, Appellate Division? And also that the gag order imposed by Judge Engoron is indeed narrowly circumscribed to say, stop posting about Judge Engoron's law clerk. Stop attacking Judge Engoron's law clerk during the pendency of this litigation. Stop making up that Judge Engoron's law clerk has these relationships with Chuck Schumer, insinuating that there's some deeper personal relationship going on. And one of the main pieces of evidence that's pointed out in this opposition brief that was just filed by the New York Attorney General's office to the temporary stay that's imposed, saying that there should not be a stay imposed, is that, like, Donald Trump just called for the citizen's arrest of Judge Engoron and said that Engoron and the New York Attorney General should be imprisoned. So when you have language like that, and then the briefing talks about all of the other cases where Donald Trump now has gag orders imposed on him because of his conduct and behavior, that this gag order is appropriate, it is not constitutionally infirm, and it needs to be maintained, and that there should not be this stay imposed. One of the things about the stay that's been imposed, a single appellate department judge said that as an administrative matter, as an administrative stay, the gag order should be lifted. And that's when Donald Trump started attacking again recently. Now it will go before a full panel at the Appellate Division for them to adjudicate this. There's the procedural argument, of course, that's being made by the New York Attorney General's office, which is that this simply doesn't fall under Article 78. And in Article 78, 78 proceeding is just not the proper vehicle to even bring a petition like this in the first place. Article 78 doesn't deal with this. This can be heard on a full appeal, and we want to talk about it later, but Article 78 or Rule 78, which is basically a lawsuit brought against the judge for kind of administrative emergency relief, is not the proper remedy. So this doesn't even fall under Article 78. But then getting deeper into, the overall argument here is, look, in addition, as noted in this high-profile trial, the Supreme Court, remember that's the trial court, Judge Engoron, has been flooded with hundreds of harassing and threatening phone calls, voicemails, emails, letters, and packages. There is a paramount interest in protecting the court staff and the functioning of the state's judiciary, especially in the overheated environment in which this trial is taking place. Indeed, any actualized threat against the court staff would have dangerous ramifications for others. It would endanger security personnel charged with protecting the court and counsel, the news media, and the public, all of whom are present in the courtroom. Notably, petitioners' free speech interests here, Trump's free speech interests here, if any, are vanishingly slim. As explained, litigants and their attorneys do not have any unfettered right to attack the integrity of trial participants during an ongoing trial, and the exceedingly narrow scope of the October 3rd and November 3rd gag orders means that at most those orders have only some minimal effect on petitioner speech rights. And this is what I've been saying on the MeidasTouch Network and on Legal AF. I said, look, it's perhaps easy for an appeals judge who sits above the trial court to go, I just don't see the problem here. I mean, it's Donald Trump just posting messages about the judge's law clerk. Doesn't he have a free speech right if he wants to post a photograph or post this? He's just posting photographs. He finds these photographs online, so what's the big deal? And here, the New York Attorney General, as we've addressed it on Legal AF, is addressing it and saying, listen, appellate judges in your ivory tower, you need to factor in the totality of the circumstances, and you're going to place court staff, court security, people walking in and out of this courtroom in personal peril, in personal danger if you continue to proceed down this path. There's real-world implications. This is not some theoretical thing that we could pontificate in a law school seminar. These are threats that are taking place to this judge, this clerk right now because of this conduct as a result of Donald Trump saying things like attacking the judge personally, attacking the law clerk personally, reposting citizens' arrest, saying that they should be criminally arrested, attacking them during a trial. And here the New York Attorney General says there needs to be equal justice under the law, and you should not be. Imagine if this wasn't Donald Trump and this was any other litigant who was out there posting about the judge and the law clerk behaving this way in the hallways of the court. Nobody would be accepting of this behavior. And if you continue to lift this gag order, you're imposing real world harm on real people in this courthouse, and you will be destroying the functioning of the judiciary. So a powerful motion here by the New York AG teams through the Solicitor General's office opposing any stay of the gag order. And again, there's a temporary stay right now on an administrative basis. And now it will go in front of a full panel, and they're going to have to understand the consequences of their order if they continue to not have this gag order ultimately imposed. I mean, I think the floodgates would be opened for litigants in New York and elsewhere. Should everybody behave like this now? No, that we are above this, and we should not be normalizing ridiculous behavior like this in a court of law. We are a nation of law and order, and this ain't law and order, the behavior by Trump and his lawyers. It makes a mockery of our system, and that's their intent. I'm Ben Meiselas from the MeidasTouch Network. Hit subscribe. We're on our way to 2 million subscribers thanks to your support. You check us out at patreon.com/MeidasTouch. We did recently a great after show where if you want to meet my mom, meet the mom of me and my brothers, check that out at patreon.com/MeidasTouch. We do a whole interview with her there. Have a great day.
Hey Midas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.